The online environment provides several opportunities for the exploitation of audiovisual content. Rights holders and distributors get access to new outlets, new audiences, and additional revenues. But the online world at the same time facilitates the development of a dark side. Commercial-scale piracy operations are gaining more and more space and erode both audiences and revenues. This is true for any protected audiovisual content, but is particularly strong impact on live events, such as sport events. It goes without saying that live sport events don't benefit by nature from the long-tail exploitation that characterizes, for example, the film industry. Apart from exceptions related to time zones, the life of a sport event lies mainly in its being watched live, which means that piracy causes immediate and unrecoverable losses, both of audience and revenues. The issue has been in the regulatory spotlight for quite some time already. On the occasion of the adoption of the Copyright Directive in 2019, the European Commission acknowledged the importance of sports events organizations and their role in the financing of sport activities in the Union, and committed to assess the challenges of sport event organizers in the digital environment, in particular issues related to the illegal online transmissions of sport broadcasts. A recent self-initiative resolution of the European Parliament of last May underlines that the problem of existing measures is that enforcement comes too late, and calls on the Commission to clarify and adapt existing legislation, including the possibility of issuing injunctions requesting the real-time blocking of access to or removal of unauthorized online content. The European Audiovisual Observatory, part of the Council of Europe in Strasbourg, has been studying the topic for almost a year now, and we will soon publish a comprehensive analysis of national remedies against online piracy of sport content. Considering that there is not much wide-ranging literature on the topic, we have been looking directly at the sources, including legislative frameworks, implementation of EU directives, or administrative and judicial case law, and we have then put everything together in a comparative perspective. We have in particular looked at the availability and the functioning of blocking and takedown injunctions, including dynamic injunctions, which are being increasingly applied against certain types of online infringements. We have detected various issues. The starting point is that sports events as such are not included in the subject matter of copyright. This is, of course, a complicating factor if we compare sport events to copyrighted audiovisual works. The well-known Premier League case of the European Court of Justice is a cornerstone judgment still 10 years after. According to the court, the issue is that sporting events cannot be regarded as intellectual creations classifiable as works, because the subject matter concerned would have to be original in the sense that it is the author's own intellectual creation. But there is a backdoor. The recording of a sport event or a broadcast may be protected where the recording meets the requirement of originality. Then comes another issue, and that is the variety of the national approaches. Exception made for two countries that have adopted specific legislation in this area, France and Italy. Most countries don't have one. Again, there is a backdoor. Sport events are often regulated by property rights, so-called domiciliary rights or house rights, concerning the venues where events take place. This means that sport events organizers may take legal action because of an unauthorized access to their premises or because of breach of contractual obligations which forbid to film, record, or broadcast the event. A third issue concerns the nature of the rights according to the different roles of the subjects involved in the exploitation of the audiovisual content. The story is quite different for organizers, sports clubs, leagues, broadcasters, and this affects directly their entitlement to take action, as also the different types of protection that may be granted. Generally speaking, all rights holders and assignees of exploitation rights are entitled to take legal actions, but the legal basis may vary, and the results, of course, as well. Depending on the legal protection that is granted, legal action may or may not be based on copyright laws. This means, in practical terms, that certain remedies like injunctions against online intermediaries, which are contained in copyright laws, are only available for rights holders or assignees. Speaking about remedies, sanctions as well are different depending on the countries. Most countries provide for both civil and criminal remedies, but long procedures are certainly not ideal for infringements that are instant, such as those concerning live sport events. Notice and takedown procedures have proven to be a faster solution, but still not the ultimate one, considering that sanctions have to be effective, proportionate, but also dissuasive. Building upon another important judgment of the European Court of Justice of 2014 in the Telecabel case, some national courts have started to allow a dynamic use of blocking orders. That is, the extension of blocking orders to future URLs, and not only to the websites currently existing. For the time being, live blocking injunctions, that is, injunctions which allow the repeated blocking of a site every time a live broadcast is in process, have been applied only in Ireland, in the Netherlands, in Spain, and in the UK. These remedies are considered to be extremely efficient, as they can be executed in a timely manner and therefore hinder active live streams. For example, in a case brought by Premier League in the Netherlands, in the Ecatel case, the Dutch High Court ordered ISPs to implement blocking orders within 30 minutes upon receiving the notification from the rights holder. English courts are playing a pioneering role in this regard, as they have widely applied live injunctions. They are addressing the blocking orders not to specific websites, but covering a list of servers from which the illegal activity was made and the corresponding IP numbers. English courts have also empowered claimants with the possibility of weekly notifying to each ISP the reset list of target servers to be blocked. Live orders are timely limited to a certain period, for example, a league season, although they can be extended for following periods of the same sport events. But these are very specific national best practices. And even among these forerunners, the time limit aspect, for example, has not been uniformly applied by courts, and significant differences still persist. From these short regulatory flashes that I have mentioned, it is evident that harmonization at European level is still missing. Considering the global outreach of internet websites and the need also for cross-border enforcement activities, the variety, if not even the fragmentation, of national solutions that have been developed so far could have a negative impact on the sound development of this segment of the audiovisual industry and also on the financing of sport activities themselves. Harmonization initiatives are based on the idea that there is an overall strategic objective and a shared vision. So maybe the time has arrived to set up some minimum common standards?